I'm Anthony Infanti. I'm the Senior Associate Dean for Academic Affairs and a Professor of Law here at the University of Pittsburgh School of Law. Earlier this week, the Supreme Court heard two hours of argument in a set of 4 consolidated cases concerning same-sex marriage. The lead case, and the one that you hear referred to in the press, is called Obergefell versus Hodges. In this video, I'm going to provide some context regarding the argument before the court, describe the argument, and talk a bit about the larger issues at stake for the LGBT community in this case. So first, for the background. Just 2 years ago, the Supreme Court heard arguments in 2 other same-sex marriage cases. In June 2013, the Supreme Court decided United States versus Windsor. In that case, it struck down the portion of the Federal Defense of Marriage Act that prohibited the federal government from recognizing same-sex marriages that were valid and recognized at the state level. In a companion case, Hollingsworth v. Perry, the Supreme Court declined to decide whether the states could prohibit same-sex couples from marrying. The court left that question for another day. Following the Windsor decision, a few state courts and a number of federal courts issued decisions striking down state bans on same-sex marriage. Though the Windsor decision was not directly on point, the courts often relied upon the Supreme Court's reasoning in Windsor when deciding that it's unconstitutional for a state to deny same-sex couples the right to marry. These decisions then percolated up through the federal appellate courts, resulting in several favorable decisions that the U.S. Supreme Court ultimately allowed to stand by refusing to review them. This series of decisions in favor of same-sex marriage dramatically expanded the number of states in which same-sex couples can marry in a very short amount of time. In June 2013, just prior to the Windsor decision, only 12 states and the District of Columbia legally permitted same-sex couples to marry. Now, less than 2 years later, same-sex couples are permitted to marry in the District of Columbia and 37 states. A small minority of courts have upheld same-sex marriage bans against constitutional challenge. One of those courts is the United States Court of Appeals for the Sixth Circuit. In November 2014, the Sixth Circuit upheld the same-sex marriage bans in 4 states: Kentucky, Michigan, Ohio, and Tennessee. With the split among the federal appellate courts, the Supreme Court accepted an appeal in these 4 cases. With these 4 cases now before it, the Supreme Court finds itself addressing the question that it left unanswered in 2013. Now a bit about the arguments this week. The arguments earlier this week in Obergefell centered on 2 questions that the court will be pondering between now and the end of June, when the court's expected to render its decision. The first question is whether the 14th Amendment requires states to extend the right to marry to same-sex couples. The second is whether the 14th Amendment requires one state to recognize same-sex marriages lawfully entered into in another state. As expected, the court was sharply divided. The 4 more conservative members of the court had many tough questions for the proponents of same-sex marriage, while the 4 more liberal members of the court had many tough questions for the opponents of same-sex marriage. Justice Kennedy, who is widely viewed as the swing vote in this case, as he has been in prior gay rights cases, had tough questions for both sides. Overall, the debate on the first question seemed more philosophical than strictly legal in nature. Among other things, the debate considered the question of line drawing. That is, if the Supreme Court extends the right to marry to same-sex couples as a matter of constitutional law, will that mean that states will have to extend the right to marry to others who are currently excluded, for example, polygamists? They also engaged in a lively debate about the definition of marriage. Justice Kennedy voiced concerns about changing a definition that had been around for quote-unquote millennia, when the court had only struck down criminal prohibitions against sodomy a little more than a decade ago. Justice Ginsburg replied that same-sex marriage certainly does not fit into the traditional pattern of marriage, which made wives legally subordinate to husbands. She contended that same-sex marriage is, however, in keeping with more modern notions of marriage as an egalitarian institution. Another basic question considered by the court is who should make the decision about extending the right to marry to same-sex couples. The proponents of same-sex marriage, including the United States Solicitor General, argued that the court should decide. The opponents of same-sex marriage argued that it should be up to the voters in individual states to decide whether and how the definition of marriage should be changed. In addressing the second question, regarding whether one state's required to legally recognize same-sex marriages entered into in another state, it was made clear early on that the court would only need to answer that question if it decided that states are not constitutionally required to extend the right to marry to same-sex couples. The argument on this question was more legalistic and centered on the appropriate standard for recognizing out-of-state marriages, in other words, whether it's compelled by the full faith and credit clause of the Constitution, or a matter of applying state choice of law rules. The court also questioned the frequency with which states, and particularly the states involved in these 4 cases, actually had refused recognition to out-of-state marriages and under what circumstances. Now a bit on the big picture. With all the momentum and excitement surrounding marriage equality, it almost seems as if marriage has become the defining issue for the LGBT community. But we can't forget that marriage has never really been the ultimate goal of the LGBT movement. Instead, marriage has only ever been a means of achieving the movement's true end goal, full acceptance in American society. As conservatives continue to push back against same-sex marriage, the LGBT community is reminded that there's still a long way to go before achieving full acceptance. Despite the tea leaf reading that will likely become a national obsession in coming weeks, the real mystery is not how the Supreme Court will rule in the Obergefell case, but just how much of a backlash the LGBT community will experience in coming years from the torrent of decisions in its favor since the Windsor decision in 2013. About a year before Windsor was decided, Justice Ginsburg remarked that the Supreme Court's decision in Roe v. Wade had triggered a decades-long backlash because it moved the country, quote-unquote, too far, too fast on the question of abortion. In the months leading up to the Windsor decision, there was much debate about whether the fear of moving too far, too fast should influence the Supreme Court as it considered the legal status of same-sex marriage at the state and federal levels. The editorial board of the New York Times, for one, correctly asserted at that time that we should not deny some people's basic rights out of fear of an angry reaction from others. But how we ought to answer a question once it's asked is different from strategizing about when and how to ask the question in the first place. This naturally should move us to consider whether the LGBT movement has pushed the several states to recognize marriage too quickly, creating hollow victories and placing obstacles in its own path to achieving the ultimate goal of full acceptance by American society. Among the states where same-sex relationships were legally recognized prior to Windsor, there was somewhat of a natural progression toward relationship recognition. These states usually first acknowledged the historic discrimination against the LGBT community and added legal protections against discrimination on the basis of sexual orientation in housing, employment, and public accommodations. These states also often took steps to legally recognize LGBT families by repealing outdated bans on adoption by lesbians and gay men, or by permitting second-parent adoption so that both spouses in a same-sex couple would be legally recognized as a child's parents. Indeed, these steps were sometimes cited in support of extending the right to marry to same-sex couples. In the wake of Windsor, however, this progression has reversed itself. Many of the states that have now been compelled by the courts to legally recognize same-sex marriage lack legal protections against discrimination on the basis of sexual orientation. In these states, the possibility of losing a job or housing or being denied service in a restaurant, for example, will obviously deter some same-sex couples from taking the step of marrying, or if they do marry, from publicly announcing or acknowledging that marriage. That's directly at odds with the LGBT movement's aim of being out and proud and advancing acceptance by society. In justifying their push for marriage equality in conservative areas of the country, national LGBT organizations cite the national consensus that is developed around legally recognizing same-sex marriage. But however real that national consensus might be, none of us lives in a national consensus. Many still face the reality of living in states or localities that are hostile to the LGBT community. It might have been a better strategy to first push for marriage equality in more liberal states, and then to leverage the building national consensus to put some of the same legal protections in place at the state or federal level before heading to court in more conservative states. But it's too late to do that now. That important work will have to come after the battle for marriage equality has ended, whether that happens this June or sometime later. The only real question now is how much harder that work and the ultimate goal of full acceptance by society will be to accomplish.